The Advocates Act and Professional Conduct 1961 as amended up to date. Advocates Act Introduction, Common Role, Bar Council of India, State Bar Council, Enrollment, Conduct, Professional Ethics, Unprofessional Conduct, Rights and Privileges, Duties, References. Question bank. Write a note on Common Role of Advocates, Bar Council of India, Legal Aid Committee. Discuss the composition and powers and functions of the disciplinary powers of the Bar Council of India. Summarize the provisions relating to admission and enrollment of advocates. What is professional ethics? An advocate should act as an officer of the court, a privileged member of the community, and a gentleman. Discuss what are the rights and privileges of advocates. An advocate has a duty to court, duty to client, duty to profession, duty to opponent, duty to himself. Elucidate. Advocates Act Salient Features. Introduction. Advocates Act passed by the Parliament. The Advocates Act passed by the Parliament received the assent of the President on 19th May 1961. Before this Act, there were different classes of legal practitioners called pleader, vakil, lawyer, attorney, revenue agent, and legal practitioners. The objectives of the Advocates Act is to integrate and constitute one class of legal practitioners called advocates. It is a common role of advocates in India and to prescribe uniform qualification for admission to the bar. The Act has created an autonomous All India Bar Council and also various state councils with powers vested inter alia to take disciplinary action in suitable cases. On enrollment, an advocate is entitled to practice in any court of India, including Supreme Court. Salient features of an advocate. Section 2A of the Advocates Act 1961 defines an advocate. According to it, an advocate means an advocate entered into any role under the provisions of this Act. Before the passing of this Act, there were different classes of legal practitioners. Advocate Act has abolished all the above classes and recognized only one class of advocates under Section 29. On merits, they are grouped as senior advocates and other advocates. The status of a senior advocate is conferred by the High Court or the Supreme Court with the consent of such advocate. The senior advocate is barred from taking minor legal work like drafting of pleadings, notices, affidavits. An advocate duly enrolled in the common role is entitled to practice in the Supreme Court and in any court, tribunal or any other judicial body where an advocate is allowed to practice. Sections 29 and 33. Any person who is not on the rolls and who practices law is liable for punishment which may extend to 6 months with imprisonment. Section 45. Common role. Section 2F, the Advocates Act, defines a common role. This means the common role of advocates prepared and maintained by the Bar Council of India under Section 20. The common role consists of the names of advocates duly entered in all the state rolls and also includes the names of Supreme Court advocates. The common role consists of two classes, senior advocates and other advocates. Any dispute to the seniority is decided by the State Bar Council in respect of the state role and by the Bar Council of India in respect of the common role. The decision of the Bar Council is final. State role. The Advocates Act defines the state role in Section 2N. It means the role of advocates prepared and maintained by the State Bar Council under Section 17. Every State Bar Council should prepare and maintain the role of advocates. This consists of the names and addresses of all persons who are advocates according to the Indian Bar Council Act, all persons who are admitted as advocates under the Advocates Act. A person cannot be enrolled in more than one State Bar Council. Each state sends the role of advocates to the Bar Council of India and also additions or omissions from time to time. The Bar Council of India prepares a common role of advocates from these state roles. Bar Council of India. Advocates Act 1961 has provided for the formation of a Bar Council of India as an autonomous body charged with certain duties and functions. Section 2E defines Bar Council of India as the Bar Council constituted under Section 4, while the territories to which this Act extends. Composition, Section 4. It consists of Bar Council of India, consists of the Attorney General of India ex officio, Solicitor General of India ex officio, one elected member from each state bar council elected from among its members. Chairman and Vice Chairman are elected by the council. Tenure Section 4. For ex officio members, the tenure is 2 years. For others, they continue as long as they hold an office as members of the State Bar Council. Status. Section 5. The Bar Council of India is a body corporate and hence a legal person. It is an autonomous body. It is a legal person having the right to acquire movable and immovable properties and to sue and be sued. It has a common seal and is having perpetual succession. It may become a member of the International Bar Association or the International Legal Aid Association and send delegates to the international conferences or seminars conducted by such bodies. Functions. Section 7 with 1973 Act. The functions of the Bar Council of India are as follows. Legal profession. To safeguard the rights, interests and privileges of advocates, to lay down standards of professional conduct and etiquette for advocates, to promote law reforms. Supervision. To supervise and control the State Bar Councils, to lay down the procedure to be followed by disciplinary committee of the State Bar Council. Legal education. To promote legal education in India and also to lay down educational standards, it should consult the universities and State Bar Councils. To recognize the law degrees given by universities for enrollment as advocates, to visit and inspect universities for that purpose. Functional. To conduct seminars, to arrange for lecture by legal experts and to publish legal journals, to organize legal aid for the poor. To reorganize foreign degree for admission to the bar. Fund collection. It may constitute one or more funds to give financial assistance, to organize welfare schemes to the needy advocates, to give legal aid to them, to receive grants or donations. Miscellaneous functions. To resolve disputes regarding seniority in the common role of advocates, to lay down rules to be followed by the disciplinary committees, to manage and invest the funds of Bar Council of India, to provide for election of its members, to perform all other functions necessary, to give directions to State Bar Council. Rule-making power. Bar Council of India has the authority to prescribe rules in various areas where it is to function under the Act. Example, to prescribe standards for legal education, to recognize foreign degrees, to prescribe the fees that may be levied, enrollment of advocates. State Bar Council, Chapter 1.4. Advocates Act 1961 is provided for a State Bar Council in each state under Section 3. Composition. Each State Bar Council consists of the Advocate General of the state ex officio, 20 members elected in accordance with the system of proportional representation by means of a single transferable vote from among the advocates of the State Bar Council. At least 10 of these must be advocates having 10 years of standing at the bar. This council elects a chairman and a vice chairman. Legal status. The Bar Council is a body corporate and hence a legal person. It is an autonomous body. It has a right to acquire and dispose of property, to sue and be sued. It has a right of succession. Tenure. The tenure of office of the elected members is 6 years. One-third of the members retire once in 2 years, like Rajya Sabha. Powers. Appointment. It is authorized to appoint the necessary staff of the State Bar Council to carry out the management of the functions. Disciplinary committees. State Bar Council has the power to constitute disciplinary committee under 3 persons, 2 members of the Bar Council and an advocate. Constituting other committees. The Bar Council may constitute standing committee called Executive Committee having 5 council members, Enrollment Committee having 3 council members and other committees. Power to make rules, Section 15. To carry out the purpose of the Advocate Act, State Bar Council is empowered to make rules relating to election members of the Bar Council, election of chairman and vice chairman, summoning of meetings, constitution of a fund, appointment of auditors. The main functions are to admit persons as advocate on roll, prepare and maintain roll, safeguard rights and privileges in interest of advocates, manage funds of the Bar Council, to promote law reform, create a fund to give financial assistance to indigent or disabled advocates, conduct seminars, to publish papers and journals, to organize legal aid to the poor. Enrollment. Persons who may be admitted as advocates on a state roll of the Bar Council. Advocate has prescribed Section 24 certain qualifications. He must be a citizen of India. He must have been a citizen of India. He must be obtained a degree of law, 3 years. Before 12th March 1967, degree in law recognized by Bar Council. After 12th March, person should have undergone a 3-year course of study in law from any university in India, or then barrister in law, etc. He must have paid an enrollment fee of 250 rupees to the State Bar Council. Procedure for enrollment. The person who desires to enroll must file an application to the State Bar Council in the prescribed form. With the necessary fee, 250 rupees, he must have the qualification prescribed in the Advocate Act, Section 24. Enrollment Committee. Application is considered by the Enrollment Committee, which shall scrutinize the same, either accept or refuse admission. If it accepts, the person shall sign the admission register after due public notice in the prescribed manner. Procedure on refusal. If the Enrollment Committee refuses to accept admission, it shall with reasons refer to the same for the opinion of the Bar Council of India and shall act according to its directions. It should notify to all State Bar Councils in India about the details of the application and ground for its refusal. Power to remove. If a person has enrolled himself by fraud, misrepresentation or undue influence, his name can be removed by the Bar Council of India after giving due opportunity to the concerned person. Appeal. If enrollment is refused by the enrollment committee, an appeal may be preferred under the Act 226 of the Constitution to the High Court. Conduct of advocates. 1. Disciplinary committee. Practice exclusive to advocates. Advocates Act recognizes advocates only as those who are entitled to practice law. They may practice in all courts in India, including Supreme Court, and before any tribunal or authority empowered to take evidence. Disciplinary committee, Section 9, composition. Consists of 3 elected members of the Bar Council and 1 co-opted member, and the senior-most person shall be the chairman of the committee. Complaint. On receipt of the complaint or otherwise, the State Bar Council shall refer the same to the disciplinary committee. The complaint must relate to the professional or other misconduct of the concerned advocate. Enquiry. The committee shall give due notice to the advocate and shall hear him. Notice to the Advocate General of India is also to be given, who shall have the right of audience. The committee may discuss the complaint, dismiss the complaint. 1. Reprimand the advocate as oral or written, then suspend the advocate for a period or remove him from the roles. That's the maximum. Review. Committee has the power to review its own order. Appeal. Any person aggrieved by the orders of the above committee may prefer an appeal to the Bar Council of India within 60 days. Disciplinary committee shall hear and dispose of an appeal. Appeal to Supreme Court. Aggrieved person may prefer an appeal to the Disciplinary Committee of the Bar Council of India to the Supreme Court within 60 days. Both are 60 days. State to central, central to Supreme Court. The court may issue a stay or dispose of the appeal. Punishment. In case of reprimanding or suspending an advocate, the punishment shall be duly recorded on the rolls of the advocate. Reprimand and suspension. In case of removal, the person's name shall be struck off from the roll. Powers of the committee. It is the same powers are vested in civil courts under CPC. It may summon and enforce attendance of any person. It may receive evidence, issue commissions. The proceedings are judicial and the committees act as a civil court. Illustrative cases. An advocate neglected to furnish the required papers to the court, which he could have easily produced. Time was repeatedly given to him by the court to produce the documents. Advocate had not informed his client about the development of the case, but had informed that the hearing date has not been announced. Held this was gross negligence and amounted to professional misconduct. Advocate for defense in a criminal case terrorized his client. Held this was professional misconduct. Advocate was barred from practicing. Chapter 2. Professional Ethics, Meanings and Scope. The legal profession is one of the noblest and brilliant professions of the world. Absolute independence is its characteristic feature. Ethics of the legal profession embodies a code of conduct, a set of standard moral principles which should be observed by the legal practitioner in relationship with his client, the court, the profession, his brethren and himself. Bar Council of India has framed the rules for professional conduct which are to be followed by members of the profession. Every profession has a code of morality, and the legal profession has its own code for observance by those who are in the profession. The first and foremost principle is that an advocate should be a gentleman. Honesty and integrity are his prized virtues in the profession. Moral excellence is like a torch in darkness. He should not falsify facts or conceal a wrong by resorting to deception. He should not accept any work which is not honorable. He should not appoint touts to canvass business for him. He should not advertise. He should not undersell himself. Junior in his profession should be treated in the kindness with seniors. Abbott summarized the qualities of an advocate in his book Seven Lamps of Advocacy. He states honesty, courage, industry, wit, eloquence, judgment, fellowship are the 7 lamps that spread light and bring glory to advocate. Let us see the 7 lamps. Mr. Ram is an advocate registered under Advocates Act after his BA LLB. He is honest. He shows courage in accepting cause of his client. He prepares with industry and hard work. He speaks with wit and eloquence in court before the judge. He studies and quotes relevant judgments as required in support of his case. He maintains good fellowship with other advocates and is active in bar council and advocates associations. These are the 7 lamps summarized in a form that can be understood. The Advocates Act 1961 provided for disciplinary action against those advocates who are guilty of professional or other misconduct. Disciplinary committee, after duly conducting an inquiry by giving notice and hearing, is empowered to suspend, reprimand, remove an advocate from the rolls. Appeal is allowed to Bar Council of India and then on to Supreme Court. If fine, the principles of professional ethics are not just the moral norms, they have the force of or sanction of the Advocates Act. Those who are guilty of misconduct shall be punished. In that direction, Advocates Act is a progressive and regulatory enactment. Unprofessional conduct. The legal profession is one of the noblest and brilliant professions of the world. As in other professions, it is a code of morals technically called professional ethics. This aims at establishing the highest standards of dignity, honesty, character, and moral excellence in profession. This onerous responsibility is on the advocates whose professional conduct should be in keeping with the established ethics of the profession. Provisions have been made in the Advocates Act 1961 to punish those who are guilty of professional misconduct. The Bar Council of India has laid down a code of professional ethics, but over the centuries, profession has evolved those ethical standards which are to be followed by advocates. It becomes a professional misconduct when these standards are not observed by the advocate. In this context, advocates should act as an officer of the court, a privileged member of the community, and a gentleman. The standards so set are briefly as follows, that is, customs made law. 1. Gentleman. The first and foremost duty of an advocate is that he should be a gentleman. The word gentleman is a compendious term that includes a great many qualities and values of the legal profession. He should uphold these at any cost and should not violate them under stresses of temptation and opportunities. Professional habits. As a professionalist, an advocate is a privileged member of the community and has a social responsibility to fulfill. To him, money making must be secondary and incidental. He must work like an artist to reach perfection. Service to society and to his fellow men should be the objective underlying his work. He should conduct himself with honesty, dignity, and sincerity. He should be industrious. He should equip himself well in the field of law and also acquire knowledge in other fields, art, science, and social sciences. His conduct should be in keeping with the great traditions of the legal profession. Officers of the court. An advocate must assist in the administration of justice. For this, he has a code of ethics to follow. Toutism. Tout is a person who acts like an agent and procures to an advocate an employment, and he does this for some consideration and remuneration paid by an advocate. He is a procurer of clients. It is a professional misconduct to appoint such touts or to get clients through them directly or indirectly. Advertisement. The general rule of professional etiquette is that an advocate should not advertise in any media to get business for him. Any such advertisement amount to unprofessional conduct. Traffic and litigation. No advocate should directly or indirectly resort to traffic and litigation. The objective is to curb the litigant's tendency in public interest. Such a traffic and litigation is an unprofessional conduct. False certificates. Filing false certificates by an advocate of the receipt of fees for obtaining a promissory note or a bond for fees is unprofessional. Misappropriation. It is a professional misconduct for an advocate to misappropriate clients' money, purchasing clients' property. An advocate should not, for himself or other persons related to him or known to him, purchase in a court action any property of his client. Negligence. Willful negligence or carelessness of the advocate in appearing or in conducting the case of his client. Failure to communicate the decision of the court to the client or its proceedings are examples. Appearing for opposite party. No advocate should directly or indirectly take up the case of the opposite party. This applies in case of appeals also. Similarly, he should not betray the confidence the client has reposed in him. The contents of the documents and records of the client should not be disclosed except with the permission of the client. He must not do anything which may damage the interest of his client. He should not make admissions or resort to compromises without the consent of his client. He should not give evidence as witness against his client. If it turns out that in the interest of justice he must give evidence, he must retire from the case before tendering evidence as a witness. It may be difficult to mention all the ethical norms which are unprofessional, but the touchstone for testing is that all those acts which are unbecoming of the legal profession are generally professional misconduct. There is an appeal in the Bar Council of India and a further appeal to the Supreme Court of India. Thus, these ethical norms have the legal sanction and are not mere moral principles. Chapter 4. Rights and Privileges of Advocates. The legal profession is one of the noblest and brilliant professions. Advocates have a number of rights and privileges apart from their duties. An advocate has a personal right or a privilege to practice law. It has a franchisee right given to him by the state. To become a member of the bar, to represent his client in any court in India and to claim audience in the court are his privileges. An advocate, while going to the court during the proceedings and while returning from the court, is exempted from a civil arrest. This privilege is based on the public interest in sound administration of justice. Section 135 Civil Procedure Code. This does not apply to arrest for contempt of court or arrest for criminal offence. With the Wakalatnama, advocate gets his exclusive privilege to represent his client. No other advocate can take up that case without his consent. An advocate is eligible to be appointed as a magistrate, munsif, or a judge of the High Court or Supreme Court as Advocate General or Attorney General of India. Advocate has a right of access to a judge in urgent judicial matters during day and night. Judge will hear the advocate beyond court hours at his discretion and convenience. An advocate has a right to his fees. Of course, he cannot sue his client for the recovery of his fees. He may exercise a lien over the documents and papers of the client. It is the privilege of an advocate to appear in the prescribed robes in courts. Though an advocate is not allowed to have any engagement except law, the Bar Council of India has in its code of ethics allowed an advocate to engage himself in various employments. He may become an MP, MLA, MLC. He may become a member of the cooperative society. He may act as an arbitrator. He may accept appointment to teach law, to write books and articles. Thus, an advocate has an enviable position in society. As a member of the learned legal profession, he has a leading role to play in the field of politics in upholding and fighting for the fundamental and other legal rights of the individuals, in uplifting and protecting the downtrodden sections of society, in espousing the cause of weaker sections of society. History is full of such illustrious advocates who have championed these causes and stood for the highest professional standards of legal profession. Our entire freedom movement was led by advocates. Chapter 5. Duties of advocates. An advocate has a duty to the court, duty to the client, duty to the profession, duty to the opponent, and duty to himself. Bar Council of India has formulated a code of duties of advocates, primary duties. An advocate should uphold the Constitution of India and assist in enforcing the fundamental rights and rule of law. He should be honest and sincere in all professional dealings. He should be a gentleman. Moral excellence is his watchword. He should maintain his dignity and self-respect and should not undersell himself. Duties to the court. Advocate should show respect to the judiciary, should not do anything to undermine its prestige. He should not exert any personal influence on the court. He should not speak ill of the judges. He must attend the hearing of the cases. He should make proper arrangement to attend if he is not able to attend personally. He should not make a show of his familiarity with the judges, nor he should do anything to affect the dignity and impartiality of the judges. He should not mislead the court by citing a repealed statute or an overruled decision. He should not make false pleadings or petitions. He should be punctual and conduct himself in the court with dignity and candor. Duty to the client. It is the primary duty of the advocate to give proper advice to his client, and for this purpose hear him patiently and use his own skill and knowledge to the best advantage of the client. He should not disclose communications which are privileged according to Evidence Act. Advocate should not accept a brief which is against his professional conduct or which is not in the best interest of administration of justice. If he is to give evidence as a witness, then he must not accept such a brief. An advocate should not refuse to defend his accused. It is his duty to put the defense of his best of his ability and protect his life and personal liberty of the individual. In civil or criminal cases, once the advocate is appointed, he should not withdraw without valid excuse. Non-payment of full fee is no reason to withdraw. Client interest in properties. An advocate should not take advantage of the confidence reposed in him by the client. He must maintain regular and correct account of all credits and debits of his client. Amounts received through the court or from other parties must be properly accounted for. He may deduct his fees and refund the balance to the client. He has a lien over documents and papers until his fee is paid. He should not have any interest in the subject matter of litigation. He should not bid or purchase his client's properties. Duty to the legal profession. Now, this is next. Toutism. Tout is a person who acts like an agent and procures to an advocate an employment and does this for some consideration and remuneration paid by the advocate. He is a procurer of clients. It is a professional misconduct to appoint such touts or to get clients through them directly or indirectly. Advertisement. The general rule of professional etiquette is that an advocate should not advertise in any media to get business for him. Any such advertisement amounts to unprofessional conduct. Traffic and litigation. No advocate should directly or indirectly resort to traffic and litigation. The objective is to curb the litigious tendency in public interest. Such a traffic and litigation is unprofessional conduct. False certificates. Filing false certificates by an advocate of the receipt of fees to obtain a promissory note or a bond for fees is unprofessional. Negligence. Willful negligence or a carelessness of the advocate in appearing or conducting the case of his client. Failure to communicate the decision of the court to the client or its proceedings are examples of misconduct. Appearing for opposite party. No advocate should directly or indirectly take up the case of the opposite party. This applies in case of appeals also. Similarly, he should not betray the confidence of the client as reposed in him. Duty to the opponent. An advocate belongs to the noblest and highly esteemed legal profession. He should be fair to the opposite party and to his advocate. No doubt, an advocate will be fighting a battle for his client, but at the same time, he is assisting the court in the administration of justice. He should give due respect to the counsel, should not interrupt unnecessarily or laugh at or do anything to degrade the opposite counsel. Duty to self. Finally, advocate should be independent, maintain dignity, professional conduct. He must be highly equipped in his profession, should be fearless and sincere. He should not tender false documents or produce knowingly false witnesses. He should not take up a false case or a case where he himself may be called as a witness. He must be industrious and tactful. According to Abbott Parry, he must have 7 qualities: honesty, courage, industry, wit, eloquence, judgment, and fellowship. Lord Eldon has said an advocate must live like a hermit and work like a horse. These qualities and duties bring success to the advocate and glory to the prestigious legal profession, of which he is proud and a privileged member. Advocates Act. Two definitions. Advocate means an advocate entered into any role under the provisions of this Act. Law graduate means a person who obtained LLB from a university. Legal practitioner means advocate, vakil, trader, mukhtar, revenue agent. State Bar Council shall consist of the following members. In case of State Bar Council of Delhi, Additional Solicitor General of India ex officio, State Bar Council, Advocate General of the State ex officio. In case of a State Bar Council with an electorate not exceeding 5,000, then you have 15 members. In case of a Bar Council exceeding 5,000 but less than 10,000, then you have 20 members. In case of a State Bar Council where electorate is more than 10,000, 25 members should be elected according to the system of proportional representation by means of a single transferable vote from amongst the advocates on electoral roll of the State Bar Council. The same method is represented for President Rajya Sabha. Provided that as nearly as possible, one half of such elected members shall be persons who have at least 10 years of being advocates on a state role. There shall be a chairman and a vice chairman in each State Bar Council elected by the council in such manner prescribed. An advocate shall be disqualified from voting at an election under subsection 2 for being chosen or being a member of the State Bar Council unless he possesses such qualification or satisfies such conditions as prescribed on his behalf by Bar Council of India. Subject to any such rules that may be made, an electoral roll shall be prepared and revised from time to time by each State Bar Council of India. There shall be a Bar Council for the territories to which the Act extends to be known as the Bar Council of India, which shall consist of Attorney General of India ex officio, Solicitor General of India ex officio, one member elected by each State Bar Council from among its members. There shall be a chairman and vice chairman of the Bar Council of India elected by the council in such manner prescribed. Term of office of a member of Bar Council of India elected by State Bar Council shall be, in the case of a Bar Council of a State Bar Council who holds office ex officio, be 2 years from the date of election till he ceases to be a member of the State Bar Council, whichever is earlier. In another case, be a period for which he holds office as a member of the State Bar Council. Bar Council to be body corporate. Every Bar Council shall be a body corporate having perpetual succession, common seal, power to acquire and hold property, movable, immovable, to contract and may be made in the name when it is to be sued, be a sue or to be sued. Functions of State Bar Council. The functions of a State Bar Council shall be to admit persons or advocates on its roll, to prepare and maintain such roll, to entertain and determine the cases of misconduct against advocates on its roll, to safeguard the rights and privileges and interests of the advocates on its roll, to promote the growth of Bar Association for the purpose of effective implementation of the welfare schemes, to promote and support law reform, to conduct seminar, organize talks on legal topics by eminent jurists and publish journals and papers of legal interest, to organize legal aid to the poor in the prescribed manner, to manage and invest funds of the Bar Council, to provide for the election of its members, to visit and inspect universities in accordance with the directions given under subclause 1 of section 7, to perform all other functions conferred on it by under the Act. To perform all other functions conferred on it by, to do all the things necessary for discharging the aforesaid functions. The State Bar Council may constitute one or more funds, giving financial assistance to organize welfare schemes for the indigent, disabled, other advocates, giving legal aid or advice in accordance with the rules made in behalf, establishing law libraries. State Bar Council may give grant, donation, gift or benefaction for all or any of the purpose specified, or should be credited to the appropriate fund or funds constituted. Functions of Bar Council of India. The functions of the Bar Council of India shall be to lay down standard of the professional conduct and etiquette of an advocate, lay down the procedure to be followed by disciplinary committee and disciplinary committee of the State Bar Council, to safeguard the rights, privileges and interests of advocates, promote and support law reform, deal with or dispose any matter arising under the Act referred to by the State Bar Council, exercise general supervision and control over State Bar Council, to promote legal education, to lay down standards of such education in consultation with the universities in India, imparting such education in State Bar Councils, to recognize universities whose degree in law shall be a qualification for enrollment as an advocate, and for that purpose to visit and inspect universities, cause the State Bar Council to visit and inspect universities in accordance with such directions as it may give in this behalf. to conduct seminar and organize talks on legal topics by eminent jurists and publish journals and papers of legal interest, to organize legal aid to the poor in the prescribed manner, to recognize on a reciprocal basis foreign qualifications in law, to manage and invest funds of the Bar Council, provide for election of its members, perform functions, to do all the things necessary. The Bar Council of India may constitute one or more funds in the prescribed manner for the purpose of giving financial assistance to organized welfare schemes for indigent, disabled, other advocate, give legal aid or advice in accordance with the rules in this behalf, establish law libraries. Bar Council of India may receive any grant, donation, gift or benefaction for all or any of the purpose specified, which shall be credited to the appropriate fund or funds. Membership of the international bodies. Bar Council of India may become a member of the international legal bodies like International Bar Association, International Legal Aid Association, contribute to some as it thinks fit to such bodies by subscription or otherwise, and authorize expenditure on the participation of representatives in international legal conference. Term of the office of the members of the State Bar Council. Term of the office of the elected member of a State Bar Council, other than elected member thereof, shall be 5 years from the date of publication of the result of his election. Constitution of a special committee. In the absence of election, ex officio member of the State Bar Council be the chairman. 2 members to be nominated by Bar Council of India from among advocates on the electoral roll of the State Bar Council to discharge the functions of the State Bar Council until the Bar Council is constituted. All properties and assets vesting in the State Bar Council shall vest in the special committee. All rights, liabilities, or obligations of the State Bar Council, whether arising out of a contract or otherwise, shall be the rights, liability, obligation of the special committee. All proceedings pending before the State Bar Council in respect of any disciplinary matter or otherwise shall stand transferred to the special committee. Shall, in accordance with such directions, the Bar Council of India may give to it on its behalf, hold elections to the State Bar Council within 6 months. Disciplinary committees. A Bar Council shall constitute 1 or more disciplinary committees, each which shall consist of 3 persons, of whom 2 shall be from the Council, from amongst members, and the other shall be a person co-opted from among advocates who possess the qualifications specified, and who are not members of the Council. And senior-most advocate will be the chairman. Constitution of Legal Aid Committee. A Bar Council may constitute 1 or more legal aid committees, each of which shall consist of such number of members, not exceeding 9, but not less than 5. Constitutional Committee under Disciplinary Committee. State Bar Council shall constitute the following standing committee. Executive Committee consisting of 5 members. Enrollment Committee consisting of 3 members. Bar Council of India shall constitute an Executive Committee consisting of 9 members, elected by the Council from among members. Legal Education Committee consisting of 10 members, of which 5 shall be elected by Council from among members, 5 shall be co-opted. Disqualification of members of Bar Council. Elected member of a Bar Council shall be deemed to have vacated his office if he is declared by the Bar Council to be absent without cause for 3 consecutive meetings, or if his name is removed from the rolls, or otherwise disqualified. Staff of Bar Council. Every Bar Council shall appoint a secretary and may appoint an accountant and such number of other persons. The secretary and the accountant. Accounts and audit. The vacancies in the Bar Council and committees thereof not to validate any action taken. No act done by a Bar Council or committee thereof shall be called in question on the ground merely of the existence of any vacancy in or any defect in the constitution of the committee. Power to make rules. Bar Council may provide for election of the members of the Bar Council by secret ballot, manner of election of the chairman and vice chairman, filling of casual vacancies, power and duties of the chairman and vice chairman. Constitution of 1 or more funds by the Bar Council for financial assistance to the legal aid to the poor. Constitution functions of the Committee of the Bar Council, term of office of the members of such committee, summoning and holding of meetings, conduct of business of such meetings, number of members for quorum, qualification and conduct of the service of secretary, accountant and other employees, maintenance of books of accounts and other books, appointment of auditors and audit, management and investment of the funds of the Bar Council, admission and enrollment of advocates. Senior and other advocate. There shall be 2 classes of advocates, senior advocate and other advocates. Advocate may, with his consent, be designated as senior advocate if the Supreme Court or a High Court is of the opinion that by virtue of his ability, that is, standing at the bar, special knowledge, or experience in law, he deserves such distinction. Senior advocate shall, in the matter of practice, subject to restrictions that the Bar Council of India may, in the interest of legal profession, prescribe. State Bar Council to maintain role of advocate. Every state bar council shall prepare and maintain a roll of advocates in which shall be entered the names and addresses of all persons who are entered as advocates on the roll of any high court under the Indian Bar Council Act. Express an intention in the prescribed manner to practice within jurisdiction of the Bar Council. All other persons who are admitted to be advocates on the roll of State Bar Council under this Act are on or after appointed day. Each such roll of advocates shall consist of two parts. First part containing name of senior advocate, second part name of other advocate. Entries in each part of the roll of advocate prepared and maintained by State Bar Council under this section shall be in the order of seniority. No person shall be enrolled as an advocate under the roll more than one State Bar Council. Transfer of a name from one state roll to the another is possible on application and approval. State Bar Council to send copies of the roll to the Bar Council of India. Certificate of enrollment. There shall be issued a certificate of enrollment in the prescribed form of the State Bar Council to every person whose name is entered in the roll of advocate maintained by it. Every person whose name is so entered shall notify any change in place of permanent residence to the State Bar Council within 90 days. Right of audience. Attorney General of India shall have pre-audience over all other advocates. Subject to provisions of subsection, Solicitor General of India shall have pre-audience over all other advocates. Subject to provision of 1 and 2, the Additional Solicitor General of India shall have pre-audience over all other advocates. That means first audience will be given to Attorney General of India, second to the Solicitor General of India, third to Additional Solicitor General of India. Subject to above, senior advocates shall have pre-audience over other advocates. Right of the pre-audience of senior advocates inter se, other advocates inter se shall be determined by the respective seniority. Persons who may be admitted as advocates on a state roll, he is a citizen of India. Provided that subject to other provisions contained in this Act, a national of any other country may be admitted as an advocate on a state roll if citizens of India duly qualified are permitted to practice law in any other country. He has completed the age of 21 years, obtained a degree of law after undergoing 3-year course in law from any university in India, recognized for the purpose by Bar Council of India, after undergoing a course of study in law, duration of which is not less than 2 academic years, is a barrister and is called to the bar. He fulfills such other conditions as may be specified in the rules by the State Bar Council. He has paid in respect of enrollment a stamp duty, enrollment fee payable to the State Bar Council of 600 rupees and the Bar Council of India 150 rupees. Scheduled caste and other tribes 100 rupees to the Bar Council of India and 25 rupees. Disqualification. No person shall be admitted as an advocate on a state roll if he is convicted on offence under moral turpitude, convicted on offence under the provisions of untouchability, dismissed or removed from employment office of any state involving moral turpitude. Disqualification of enrollment as aforesaid shall cease to have effect after a period of 2 years have elapsed since his release or dismissal, or the case may be after removal. Authority to whom application for enrollment may be made. Application for admission as an advocate shall be made in the prescribed form to the State Bar Council within whose jurisdiction applicant proposes to practice. Disposal of application for admission as an advocate. A State Bar Council shall refer every application for admission as an advocate to its enrollment committee, subject to provisions of subsection 2, 3 of 6. Any direction given in writing by the State Bar Council, such committee shall dispose of the application in a prescribed manner, provided the Bar Council of India may, if satisfied, either in a reference made to it on his behalf, or otherwise that any person has got his name entered in the roll of advocates by misrepresentation, or to an essential fact or by fraud or undue influence, remove the name of such person from the roll of advocates, after giving him an opportunity of being heard. If an enrollment committee of the State Bar Council proposes to refuse any such application, it shall refer the application for opinion to the Bar Council of India, and every such reference shall be accompanied by a statement of the grounds in support of the refusal of the application. Where the enrollment committee of a State Bar Council has refused an application for admission as advocate on roll, the State Bar Council shall, as soon as may be, intimation to all the State Bar Councils about such refusal, state the name, address, qualification of the person whose application was refused and the grounds for refusal. Power to remove names from roll. State Bar Council may remove from the state roll the name of an advocate who is dead or from whom a request has been received. Application once refused not to be entertained by any other Bar Council, except in certain circumstances, except with the previous consent in writing of the State Bar Council which refused the application, the Bar Council of India, and of Bar Council of India. Power to make rules. State Bar Council may make rules to carry out the proposed purpose of this chapter. Right to practice. Advocate is the only recognized class of persons entitled to practice law in courts in India. Right of advocates. Subject to the provisions of this Act, every advocate whose name is entered in state roll shall be entitled as right to practice throughout the territories in which India extends, in all courts of Supreme Court, before any tribunal, any other authority. Power of court to permit appearances. Notwithstanding anything contained in the chapter, any court authority or a person may permit any person not enrolled as advocate to appear before it and to him in any particular case. Advocates alone are entitled to practice. Power of High Court to make rules. High Court may make rules laying down the conditions subject to which an advocate shall be permitted to practice in the High Court and courts subordinate thereto. Chapter 5. Conduct of Advocates. Punishment of advocate for misconduct. Where on receipt of complaint or otherwise, a State Bar Council has reason to believe that any advocate on its roll has been guilty of professional or other misconduct, it shall refer the case for disposal to its disciplinary committee. State Bar Council may, either on its own motion or an application made to it by any person interested, withdraw a proceeding pending before its disciplinary committee and direct the inquiry to be made by any other disciplinary committee of the State Bar Council. Disciplinary committee of a State Bar Council shall fix a date for hearing of the case and shall cause a notice thereof to be given to advocate concerned and to the Advocate General of the State. Disciplinary committee of the State Bar Council, after giving advocate concerned and the Advocate General an opportunity of being heard, may make any of the following orders. 1. Dismiss the complaint, or where proceedings were initiated at the instance of State Bar Council, direct the proceedings be filed. Reprimand the advocate, suspend the advocate from practice for a period, remove the name of the advocate from a roll. Where an advocate is suspended from practice, he shall, during suspension, be debarred from practicing in any court or before any authority and person in India. Disciplinary powers of the Bar Council of India. Where on receipt of a complaint or otherwise the Bar Council of India has reason to believe that any advocate whose name is not entered in any state roll has been guilty of professional or other misconduct, it shall refer the case for disposal to a disciplinary committee. Notwithstanding anything contained in this chapter, disciplinary committee of the Bar Council of India may, either on its own motion, report by the State Bar Council or an application made to it by any person interested, withdraw for inquiry before itself any proceedings for disciplinary action against any advocate pending before disciplinary committee of any State Bar Council and dispose the same. Disciplinary committee of the Bar Council of India, in disposing of any case under this section, shall observe as far as possible procedure laid down in section 35, reference to the Advocate General in the section being construed as reference to Attorney General of India. In disposing of any proceeding, the disciplinary committee of the Bar Council may make any order under which the disciplinary committee of State Bar Council can make such an order. Disposal of disciplinary commission. Disciplinary committee of State Bar Council shall dispose of the complaint received by it under section 35 expeditiously. In each case, proceedings shall be concluded within a period of 1 year from the date of receipt of the complaint or the date of the initiation of proceedings at the instance of the State Bar Council. Failing which, such proceedings shall stand transferred to the Bar Council of India, which may dispose of the same as if it were proceedings withdrawn from inquiry under subsection 36(2)(2). Appeal to Bar Council of India. Any person aggrieved by an order of the Disciplinary Committee of the State Bar Council may make, within 60 days of the date of communication of the order to him, prefer an appeal to Bar Council of India. Every such appeal shall be heard by the Disciplinary Committee of the Bar Council of India, which may pass such order, including an order varying the punishment awarded by the Disciplinary Committee of the State Bar Council thereon as it deems fit, provided that no other disciplinary committee of the State Bar Council shall be varied by the Disciplinary Committee of the Bar Council of India as to prejudicially affect the person aggrieved without giving him a reasonable opportunity of being heard. Adi alteram partem. Appeal to the Supreme Court. Any person aggrieved by an order made by the Disciplinary Committee of the Bar Council of India under section 36 or 37 clause 2, Attorney General of India or Advocate General of India concerned as the case may be, may, within 60 days from the date on which the order is communicated to him, prefer an appeal to Supreme Court, or Supreme Court may pass such order, order number 2, including order varying the punishment awarded by the Disciplinary Committee of the Bar Council of India, thereon as it deems fit. Provided that no order of the Disciplinary Committee of the Bar Council of India shall be varied by the Supreme Court so as to prejudicially affect the person aggrieved without giving him a reasonable opportunity of being heard. Stay of order. An appeal made under 37 or 38 shall not operate as a stay of the order appealed against, but the Disciplinary Committee of the Bar Council of India and the Supreme Court, as the case may be, by sufficient cause, direct the stay of such order on such terms and conditions as may deem fit. Where an application is made for stay of the order before expiration of the time allowed for appealing there from the under section 37 or 74 or section 38, the Disciplinary Committee of the State Bar Council or the Disciplinary Committee of the Bar Council of India, as the case may be, for sufficient cause, that the stay of such order on such terms and conditions as may deem fit. Alienation. Alteration in role of advocates. Where an order is made under chapter reprimanding and suspending an advocate, a record of the punishment shall be entered in his name. In case of an advocate whose name is entered in a state roll, in that roll, Where any order is by removing an advocate from practice, his name should be struck off the state roll. Where any advocate is suspended or removed from practice, certificate granted to him under Section 22 in respect of the enrollment shall be recalled. Powers of Disciplinary Committee. Disciplinary Committee of a Bar Council shall have the same powers that vested in Civil Court, Civil Procedure Code 1908. In respect of the following matters, namely, summon and enforce attendance of any person examined on oath, require discovery and production of documents, receive evidence and affidavit, requisition any public record or copies thereof, issue commissions for examination of the witnesses or documents. Any other matter, provided that no such disciplinary committee shall have the right to require attendance of 1. Presiding officer of a court except with the High Court permission, an officer of the Revenue Court except the permission of the state government. All proceedings before disciplinary committee of the Bar Council shall be deemed judicial proceedings. Where no final order of the nature referred to above 35 clause 3 can be made in any proceedings in accordance with the opinion of the chairman and members of the disciplinary committee, either for want of majority opinion among themselves or otherwise, the case with their opinion thereon shall be laid before the chairman of the Bar Council concerned, or the chairman of the Bar Council acting as chairman or member of the disciplinary committee before the vice chairman of the Bar Council, and the said chairman or vice chairman of the Bar Council, as the case may be, after such hearing as thinks fit, shall deliver his opinion, and the final order of the disciplinary committee shall follow such opinion. Next, review of orders by disciplinary committee. Disciplinary committee of Bar Council makes its own motion, otherwise review any other order within 60 days from the date of the order passed by it under the chapter. Provided that review of the disciplinary committee of Bar Council may by its own motion otherwise order within 60 days of the date of the order passed by it under the chapter, provided no such order review shall have the effect unless it is approved by the Bar Council. Penalty for persons illegally practicing in courts before other authority. Any person who practices in a court before any authority in or before whom he is not entitled to practice under provisions shall be punishable with imprisonment of 6 months. Power of revision. Bar Council of India may call for record of any proceeding under the Act which has been disposed of by a state bar council or committees thereof, or from no appeal lies for the purpose of satisfying itself with the legality or propriety of such disposal, and may pass such orders in relation thereto as it may think fit. No order which prejudicially affect any person shall be passed under this section without giving him a reasonable opportunity of being heard. Review. Bar Council of India, any of its committee other than disciplinary committee may of its own motion otherwise review any order within 60 days from the date of the order passed by the under. Power to give directions. For the proper and efficient discharge of functions of a state bar council, any committee thereof, Bar Council may, in exercise of its powers of general supervision and control, give such direction to state bar council and committee thereof as may appear necessary. State bar council shall comply. General power of the Bar Council of India. Bar Council of India may make rules for discharging its function under this Act, and in particular the rules may prescribe conditions subject to an advocate may be entitled to vote at an election of State Bar Council, including qualifications and qualification of voters, and the manner in which electoral rolls of voters may be prepared and revised by State Bar Council. Qualification for membership by Bar Council or qualification for such membership, time within which the manner in which the effect may be given to the proviso, Section 3, Clause 2, manner in which the name of the advocate may be prevented from being entered in more than one state roll, manner in which the seniority among advocates may be determined, minimum qualification required for admission to a course of degree in law recognized by university, class of category of persons entitled to be enrolled as advocates, conditions subject to which an advocate shall have the right to practice, and the circumstances under which a person shall be deemed to be practiced as an advocate in court, the form in which application shall be made for the transfer of the name of advocate from one state role to another, standard of professional conduct and etiquette must be observed, standard of legal education to be observed by University of India and inspection of universities thereof. Foreign qualification. In law obtained by other persons other than citizens of India who shall be recognized for the purpose of admission as an advocate under this Act. Procedure to be followed by the disciplinary committee of the State Bar Council by its own disciplinary committee. Restriction in the matter of practice to which certain advocates shall be subject. Form of dresses or robes to be worn by advocate having regard to the climatic conditions. Fees which may be levied in respect of any matter under this Act. General principles of guidance of Bar Council, State Bar Council of India. Manner in which directions issued by orders of Bar Council of India may be enforced. Any other matter.